Other offences, such as criminal damage or arson or threatening behaviour or assault or possession of weapons committed in the context of widespread disorder, will be regarded as aggravated forms of that offending. Also, it matters not that a particular offender voluntarily present at the scene of a disturbance did not instigate the disorder or play a leading role, or themselves throw a missile at the police or cause particular damage. As has often been observed in cases such as this, it is an unavoidable feature of mass disorder that each participant's act, whatever it might have been when considered in isolation, is capable of stirring up and encouraging others to behave in a similar way, and that the harm to the public stems from the combined effect of what is done by everyone who is present. Having set out those general principles, I now turn to deal with the offences to which each of you has pleaded guilty. For the offence of violent disorder and the offence of possessing an offensive weapon, there are sentencing guidelines which I must and will follow. And principally, my task is to determine in each of your cases separately your individual culpability and the harm each of you caused. Dealing firstly with you, John O'Malley. You're 43 years of age now, and you were present from an early stage at the disturbance on St Luke's Road in Southport. There is very clear footage showing the developing disorder, and you were at the front of what was essentially a baying mob. You were part of a surge that broke through police lines, and you were standing next to the police vehicle that was being destroyed. You were present while missiles of every description were raining down on the officers, including bricks, traffic cones, wheelie bins, road signs, tins of paint, and the occasional firework. It was relentless, and you were at the front and participating enthusiastically. I have seen the footage, and there were plenty of opportunities for anyone to leave who did not want to be there. You were arrested 5 days later and made no comment in interview. You have 2 previous convictions, including a recent one for assault by beating. You have, of course, pleaded guilty, and you are entitled to full credit for that plea. I'm told that you now deeply regret what you did on that night. But apart from that, there is very little further mitigation available to you. Turning to the sentencing guidelines, I am satisfied that your offending falls into culpability category B, because you participated willingly in an incident involving widespread and large-scale acts of violence on both people and property, where there had obviously been planning by someone, and it lasted for several hours. In terms of the harm caused, it is category 1, because almost every category 2 factor is present, and they have to do with the significant resulting injury and fear and distress, and the serious disruption and impact on the community. The starting point for a category B1 violent disorder is 3 years imprisonment, with a range up to 4 years. In your case, there are significant aggravating features which have not already been taken into account and which justify a substantial upward adjustment in the starting point. You have a previous conviction for an offence of violence. More significantly, you were part of a crowd using obviously racist and religiously intolerant language that was demonstrating quite deliberately outside a mosque. And you were an active and persistent participant, and this combination of factors takes the sentence, in my judgment, to the top of the relevant bracket. Dealing next with you, William Nelson Morgan, you are 69 years of age now, but your advancing years plainly did not prevent you from playing an active part at the disturbance on County Road. You were a part of a crowd of about 100 people who were running amok, setting fire to bins and damaging local property, including a community hub and library which contained a food bank and provided an important resource for the people living in that area, that library and hub based at Spellow Lane. The crowd threw bricks that night and bottles, and bins were set on fire, and they too were hurled at the defending police officers. As those officers were trying to regain control, you were seen at the front of the mob, holding in your hand a wooden kosh, a small truncheon, which you plainly had with you to use as a weapon. But when officers tried to arrest you, you resisted with such force that it took 3 of them to detain you. And later, when asked about the kosh, you said, remarkably, that you had taken it with you that night for your own protection. For the same reasons as your co-accused, I am satisfied that this is Category B1 offending. There is no suggestion that the incidents in Walton were racially or religiously aggravated, and there may not have been as many people present. But there was looting of commercial premises. There was the wanton attempt to destroy by fire the local library and community hub, and many, many more fireworks were thrown at the police. In your case, there is the serious aggravating factor that you were in possession of a weapon, the kosh, which I am sure you had with you to use to cause injury if the opportunity should arise. It was visible when you were confronting the officers at a time when there was serious public disorder. That factor, together with the other aggravating factors, again justifies a very significant upward adjustment from the starting point, and because of the factor of that weapon, in my judgment, takes your offending beyond the top of that relevant bracket. Because I am taking the weapon offence into account in that way, the sentence for that offence will be ordered to run concurrently rather than consecutively, as might otherwise have been the case. In terms of mitigation, you have no previous convictions at all, and it is very sad indeed to see someone of your age and character in the dock of a Crown Court. That good character is something which I must reflect to some extent in terms of assessing the overall sentence, and the sentence I will pass will reflect it, but the weight to be attached to such mitigation can only be limited given the need in all of these cases for appropriate punishment and deterrence. I impose in both your cases the statutory surcharge in whatever is the appropriate amount, and I make a collection order. The sentences that I am about to impose have been reduced by 1/3 to reflect your pleas of guilty, and you will both serve up to 1/2 of those sentences in custody before you are released on licence. If you fail to abide by the conditions of your licences, you can be returned to serve some or all of the remainder of those sentences. Will you both now stand up? In your case, John O'Malley, for the offence of violent disorder, the sentence is 32 months imprisonment. In your case, William Nelson Morgan, for the offence of violent disorder, the sentence is also 32 months imprisonment. That sentence intended to reflect that offence and the associated offence of possessing an offensive weapon. For the associated offence, there will be a concurrent sentence of 6 months imprisonment, reflecting, as I have, the principle of totality. The total sentence is therefore one of 32 months imprisonment in your case. Because of your possession of the weapon, I am also satisfied that it is necessary to make a serious violence reduction order to protect the public from future harm. It will last for a period of 2 years and will not take effect until you are released from custody. Those are the sentences of this court. You may now both go with the officers.